Alright, so we're going to do Chapter 12 here, Deeds. So Chapter 12, Deeds, starts on page 297 in the book, so we'll get right into it here. So first and foremost, what is a deed? What a deed does, that transfers interest right or title to realty. So when you buy a house, what the seller gives to a buyer is called a deed. Since the seller can actually pick up the land and carry it with them to the closing table, instead what they give to the buyer at the closing table is they give them a deed, and that's what transfers ownership. So for starters, we'll write this up here, what a deed does. It transfers interest right or title to realty. So first and foremost, a deed transfers interest right or title to realty. Now, another question they could ask about that in regards to the deed, they could say, where do you find the most complete legal description of the property? You'd find the most complete legal description of the property in the deed, because the deed is telling you what you own, and therefore you have to know what you own. So it's gonna have the most complete legal description of the property. So number 2 for deed, if they were to ask you, where do you find the most complete legal description of the property, you'd find that in the deed. So number 2 here, the deed, that's where you would find the most complete legal description of property. So again, the deed, that is where you would find the most complete legal description of the property. So here's 2 basic things to start off with this chapter here. Again, the deed transfers interest right or title to realty. It's also where you would find the most complete legal description of the property. Now next here, as we move on to other topics here in chapter 12, number 1 talks about how deeds can be transferred. If deeds can be transferred testate, intestate, when you die testate, when you die intestate, first and foremost, what does that mean? If you die intestate, that means you die without a will. If you die without a will, then your property is going to transfer by what's called the law of descent. The law of descent means who's most closely related to you. And typically we'll go spouse, children, grandchildren, so on and so forth afterwards. Whereas if you die testate means you die with a will. If you die with a will, then your property transfers according to what your will says. So if I die with a will and it says, when I die, give it to John Smith, my executor, who's handling my will give the property to John Smith in that case. So number 1 here on the left side of page 297 says, if you die intestate, how does your property transfer? By the law of descent. If you die testate, you die with a will, your property then transfers according to your will. We'll talk about this in other chapters. Now number 3 here gets into this term here, involuntary alienation. Your deed can transfer by what's called involuntary alienation. What involuntary alienation basically is, that's when I involuntarily convey or transfer my property. Because the term alienation means to convey or transfer property. So if I'm involuntarily alienating my property, I'm involuntarily conveying or transferring it. Now, examples of involuntary alienation, think of it this way. You're not raising your hand and asking for it. So if I stop paying my property taxes, the government can auction off a property tax lien. After 2 years of not paying that back, somebody can come in and foreclose on my property. If they auction off my property tax lien, am I raising my hand saying, hey, make sure you foreclose on me? No, I'm not doing that, right? So that's an example of involuntary alienation. Another example would just be a strict foreclosure. If I stop paying the bank, it's not like I raise my hand and say, hey, please foreclose on me. Again, another example of involuntary alienation. But the term I want to write up here is the term alienation, because what alienation means is to convey or transfer property. So again, this term here, alienation, that simply means to convey or transfer property. So again, 2 examples we said for involuntary alienation, foreclosure, or tax lien foreclosure. One of those could be an example. Maybe even condemnation. Government comes in and condemns my house. Again, I don't raise my hand and say, hey, please condemn me. That's involuntary alienation. Now, voluntary alienation, what's a good example of when you're voluntarily conveying or transferring your home? Good example of that's a regular sale. So I put my house on the market, I sell it, I stick a sign on the ground, I'm waving my hand saying, hey, come here, we want you to buy our house. That's an example of voluntary alienation. Again, when you're voluntarily conveying or transferring your home. Now, the next term that we're going to get into here is under number 4 on 297. And here it talks about grantor and grantee. Now, the reason I bring this up is because the grantor and grantee is basically used to describe a buyer and seller in a deed. The party who gives the deed is called the grantor. the party who receives the deed is called the grantee. Now, obviously, these aren't things that we talk about with our sellers about, in regards to even giving them advice on what type of deed to be transferred. That's not our job. That's their attorney's job. If we were to actually give them advice on types of deeds to take, we'd actually be violating, we'd be practicing the unauthorized practice of law. So you wouldn't want to do those things. So, but for test purposes, they might ask you, the party who receives the deed, in other words, the buyer basically, is best described as that's grantee. The party who gives a deed, in other words, the seller in a deed, is called the grantor. The reason I'm bringing this up is they try to confuse you on the test. They talk about buyers and sellers in reference to sales contracts, also in reference to deeds. So if you're talking about a buyer and seller in a sales contract, it's vendor-vendee. The vendor is a seller in a sales contract, the vendee is the buyer. In a deed, the party who gives the deed, in other words, the seller basically, is the grantor. The party who receives that deed is called the grantee. So keep that in mind. So again, if you're talking about buyers and sellers with sales contracts, it's vendor-vendee. Vendor being the seller, think of like a hot dog vendor at a baseball game, they're selling hot dogs. The vendee is the buyer. And then again, if we're talking about deeds, it's going to be grantor-grantee. So I'll write this up here now. With deeds, we use grantor-grantee. The grantor, the party who gives the deed. The grantee, the party who receives it. Again, with deeds, we have grantor and we have grantee. Grantor, we say gives the deed. Grantee, we say receives the deed. So that's an example for number 4 here. And then at the bottom here, on the bottom left of 297, you'll see a bolded term here called dedication. So in regards to a dedication is a gift of property to the government. So if you want to gift property to the government, we call that a dedication. Now, something we're going to talk about later in this chapter is that if I want to give property to the government, they don't have to take it. Because in order for a deed to be valid, there must be voluntary delivery and acceptance, meaning that I voluntarily give to them and they voluntarily accept it. So in regards to a dedication, what a dedication is, that's me giving property to the government. It's totally at their discretion if they want to accept it. Give you guys an example where they wouldn't accept it. Let's say I have a property that has a ton of contamination on it. Are they going to want to take on $1 million liability for a cleanup? Probably not. So in that case, they won't accept that, so I can't give it to them. But if they do accept it, we call it a dedication. So I'm going to write this up here. A dedication, it's a gift of property to the government. But keep in mind, with the dedication, there must be voluntary delivery and acceptance. I can't just stick it on them. So again, dedication, gift of property to the government. So the term here, dedication. This is a gift of property to the government. And again, it's really at their discretion whether or not they'd like to accept it. So that's a dedication, simply a gift of property to the government. Next here, what we're going to start getting into is the different types of deeds. There's really 3 main types of deeds, the 3 main ones for us to know about. We're going to talk about the general warranty deed. We're going to talk about the special warranty deed, sometimes called the bargain and sale CVG. And we're also going to talk about the quitclaim deed. Those are the 3 main types that we're going to talk about. We're going to start here on the top right of 297 with the general warranty deed. So we're going to start with that now. I'm going to erase the space up here and get the details about the general warranty deed. So again, right now we're going to talk about the general warranty deed. So general warranty deed. Now, just so you guys know, with the general warranty deed, these really aren't used that commonly today. And the reason is because we have title insurance now. Title insurance is going to say, we're going to protect you for everything that happened prior to your acquisition of title. What the general warranty deed does, though, if somebody were to grant this, you're giving somebody your deed, you're basically giving property to somebody, and you're assuring them that I promise you that basically this deed is free and clear of defects back to forever. So back to when dinosaurs roamed the land, basically. So by doing this, they impose a huge liability on themselves. They don't know what happened there, 75, 80, 90, 100 years ago, right? But they're promising you that it's free and clear of defects back to forever, to the point that if somebody ever put a claim in against that title, they would be the ones who would have to step in and protect you. They would be the ones who would incur the liability, things like that. Now, on the flip side of it imposing a huge liability on the grantor, who would you imagine that it provides with a huge protection? The grantee. because the grantee is being promised. This thing's good back to forever. Anything ever pops up, I call the grantor, they take care of it for me. So realistically, these really aren't used too commonly. But the general warranty deed, just to define it, first and foremost, basically what it is, the grantor states to the grantee, I'm promising you that this deed is free and clear of defects back to forever. So again, if anything pops up, I'm going to come in and protect you. So here, the grantor states to grantee that deed is free and clear of defects, basically back to forever. I know that sounds like a stupid term, but that's the way I explain it. So that the deed is free and clear of defects back to forever. Now, as I said, they could ask you on the test, they could say something like, which of the following deeds imposes the greatest liability on the grantor? This right here, because I'm saying it's good back to forever, then anything pops up, I'm going to protect you. So number two, if they ask you what deed imposed the greatest liability on the grantor, it's this right here. So a general warranty deed imposes greatest liability on grantor. Now, the flip side of that, it provides the grantee with the highest level of protection. They're being promised this deed's good back to forever, and if it's not, grantor is going to protect you. So number three here, if they ask you what type of deed provides the grantee with the greatest protection, this right here. Number three provides grantee with greatest protection. It provides the grantee with the greatest protection. So this here is the general warranty deed. Now you'll see some covenants listed here on the right side of 297. The one that I think is important to know is A, the covenant of season. If you have a covenant of season placed in one of these deeds, the covenant of season, that's where the grantor states, I actually do own the property and have the right to convey it to you. A lot of people would say, well, when I see that, well, why would they have to say they own the property and have the right to convey it to me? Wouldn't that automatically be assumed? Not necessarily, because one of the types of deeds that we're going to talk about in the next page or so is what's called a quitclaim deed. With a quitclaim deed, what happens there, the grantor just gives to the grantee any interest they have in the property, which could be fee simple, the highest degree of ownership, could be down all the way to nothing at all. I'll give you guys a stupid example of that. I could sign my rights in the Empire State Building over to anybody right now. They'd get nothing because I don't own the Empire State Building, but again, what the quitclaim deed does, it transfers any interest the grantor has to the grantee. So the covenant of season, here you would actually say, I actually do own this property and have the right to convey it to you. So I'll write this up here. The covenant of season is found in a deed. Here's where the grantor states they actually do own the property and have the right to convey it to another party. Again, the covenant of season. So here the grantor states they own the property and have the right to convey to another party. So again, the covenant of season, here the grantor states they actually do own the property and have the right to convey it to another party. So again, that's called the covenant of season. All right, if you turn the page here, go to page 298. 298 here, number 2, it's called the Bargain and Sale Deed with Covenants Against Grantors Acts, more commonly called the Bargain and Sale CVG. We're going to call this a Special Warranty Deed. Now, they could call it the Bargain and Sale Covenants vs. Grantors Acts or Special Warranty. Bargain and Sale Deed with Covenants vs. Grantors Acts just is a lot longer to write on the board. So on the board, I'm going to write up here as a Special Warranty Deed. So let me just get this up here for you now. And again, this is the most common type of deed called the Special Warranty Deed. So Special Warranty Deed. So what happens here is that essentially the grantor states to the grantee, I do own the property, and during my ownership, I've done nothing to really encumber this title that I will not have removed prior to closing. If there's things that I won't have removed prior to closing, I'm going to disclose to you, what those things happen to be. So this is the most common type of deed. It's basically going to say that if I have a mortgage on my property, when I go to sell, I'm going to pay that loan off. If I have a construction lien because I didn't pay a contractor, I'm going to pay that off at closing, things like that. So for the special warranty deed, what happens here, the grantor says to the grantee, again, during my ownership period, I've done nothing to encumber the title that I will not have removed prior to closing. So what happens here is that grantor states to grantee that during their ownership, they've done nothing to encumber title that will not be removed or disclosed prior to closing. So again, for the special warranty deed, the grantor states to the grantee that during their ownership, they've done nothing to encumber the title that has not been disclosed to them or will not be removed prior to closing. So that's the special warranty deed here. And the next one to go over here is listed as number 4, the quitclaim deed. With the quitclaim deed, as far as functionality and what it is, those are really two different things. Realistically, where a quitclaim deed is used, it's used primarily to remove a cloud on a title. So if there's some kind of discrepancy or a cloud on the title, we would wind up using a quitclaim deed to remove that. With that being said, the quitclaim deed technically just transfers any interest the grantor has to the grantee. So homes that I own, I can sell to you guys, and when I sell these homes to you, I could transfer them through a quitclaim deed. Now I won't. I would probably transfer through that bargain and sale CVG we just talked about, the special warranty deed. But if I wanted to, I could transfer it through a quitclaim deed, because what the quitclaim deed does, it simply transfers any interest the grantor has to the grantee. Could be fee simple, the highest degree of ownership. Could be all the way down to nothing at all. So simply what a quitclaim deed does, it transfers any interest the grantor has to the grantee. So, and again, we have to know functionality for this, though. Where is it actually used? On the test, they might ask you, what type of deed might be used to remove a cloud on the title? That is a quitclaim deed. So I'll write those things up here now. So again, this is called a quitclaim deed. So a quitclaim deed. Number 1, what does it do? It transfers any interest the grantor has to the grantee. So it transfers interest grantor as to grantee. And from a functionality standpoint, it would be used to remove a cloud on a title. So again, what does this do? It's used to remove clouds on title. So again, from a functionality standpoint, it's going to be used to remove clouds on title. So again, these would be the main things to take away really for a quitclaim deed. So again, definition-wise, it transfers any interest the grantor has to the grantee. Could be fee simple, could be all the way down to nothing at all. And again, number 2 here, where is it functionally used? To remove clouds on titles. And then we get into deeds for a special purpose here. So like an administrator's deed. If somebody dies intestate, you die without a will, the court appoints an administrator to distribute your estate. The deed that might be used is called an administrator's deed. Correction deed number 2. Somebody misspells a name in a deed. Correction deed. Fixes that misspelling. Number 3 here, the deed of trust. We're going to go over that more so in Chapter 14. That's an alternative to a mortgage where basically the seller takes back a note as part of the purchase price, but rather than the seller giving the buyer the deed, they give it to a neutral third-party trustee who holds on to that deed in trust. Don't worry about that now. We're going to talk about that in Chapter 14 with the mortgages. Executor's deed. If you die and you have a will, and your will you name an executor, that executor is then going to transfer your property. Gift deed is what it sounds like, transfer a gift. Guardian's deed, if a guardian is going to be transferring property. Guardian's deed. The one that I think is probably the most important of all these is the sheriff's deed. A sheriff's deed is used to transfer a foreclosure sale. Now, the bank can foreclose and they can own the property and hold it as what we call like an REO. But if they ask it on the test, if they just say, what type of deed transfers a foreclosure sale, they're probably looking for a sheriff's deed. So again, a sheriff's deed, if you have like a sheriff's sale, they're going to use a sheriff's deed to transfer that ownership. So if you just want to write down for number 7, again, the sheriff's deed that is used to transfer a foreclosure sale. All right, and then next here what we're going to get into is on the bottom right of 298? Yeah, 298, elements of a deed. So in regards to elements of a deed, there's a bunch of them. Some are essential, some are not essential. What we're going to focus on is the essential ones. We'll go through each one by one and explain which one is essential. So the first one here, written instrument. Technically, nothing has to be in writing. We've talked about this in the contracts chapter where verbal and oral agreements are valid. They're just not enforceable due to what's called the statute of frauds. Technically, deeds are not required to be in writing. You could hypothetically have a verbal deed. Nobody's going to have a verbal deed in real life, but you could hypothetically have one because nothing is required to be in writing unless you want it to be enforceable in a court of law. So number 1, believe it or not, is not essential. Number 2, date. Believe it or not, also not essential. In real life, these things are you're going to have a written deed, you're going to have a date and things like that, but date is not an essential item either. So number 3 here, this is where we start getting into the grantor versus the grantee. What are the requirements of the grantor of the deed? What are the requirements of the grantee? That's what I'm going to go over now. I'm going to put them side by side up here. So the differences between the grantor and the grantee in a deed. So grantor and grantee. First and foremost, the first thing to note is which one has to be a competent party. The grantor, the party who's giving the deed, must be a competent party. What is a competent party? Somebody who is 18 years of age, of sound mind and memory. The grantee does not have to be a competent party. The grantee simply has to be named. So to give you guys an example, let's say, God forbid, a couple goes out to dinner, they get in a car accident, and they die. And they have 2 young children, ages 4 and 2. They could leave everything they own to the 4 and 2-year-old and name them as the grantees. Now, when those 4 and 2-year-olds inherit all the property, can they turn around like a month later and sell it for video games? No, they can't do that. Why? Because they're not a competent party. They're probably going to have a guardian overseeing that property until they hit a certain age in that case. So for the grantor, first thing to note, the grantor must be a competent party. The grantee does not have to be a competent party. Could they be? Of course, but they're not required to be. So grantor must be a competent party. Grantee does not have to be a competent party. They just have to be named. So again, the grantee does not have to be a competent party. Now, as I said, deeds are not required to be in writing. However, they probably will be in writing with that said, obviously. So if the deed is in writing, obviously, somebody's going to sign off on it. The only person who signs the deed is the grantor. The grantee never, ever, ever signs the deed. The grantee is just named. So if they were to ask questions on that, like, who signs the deed, who's named the deed, things like that, the grantor, if the deed's in writing, they're going to sign the deed. The grantee is strictly just named. So again, the grantor, they would sign the deed. And the grantee, they are just simply named in the deed. So again, the grantor signs the deed, and the grantee is just simply named. And then on the left side here of 299, it talks about things like recital of consideration, words of conveyance, things like that. The next important thing to note here is on the bottom left of 299, number 7, the habitum clause. So the habitum clause, this is a clause in a deed that states what you're getting. So we said the habitum clause, what it does, it either states or limits the quantity of real estate being conveyed. So like, it's always going to start off with these words, to have and to hold, and it tells you what you get. Like, to have and to hold fee simple interest in 123 Main Street. That's to have and to hold the highest degree of ownership in 123 Main Street. It could say to have and to hold fee or qualified fee interest in 123 Main Street, and I'm going to reserve myself the right to cross over your property, get up to the beach. Now you're limiting what you're giving to that person. So what this habitum clause does, it always starts with those words to have and to hold. So the habitum clause, what we say that does, it either states or limits the quantity of real estate being conveyed. So again, this term here, habitum clause, this states or limits the quantity of realty to be conveyed. So again, the habetum clause that either states or limits the quantity of realty to be conveyed. And then number 8 here talks about the legal description. I talked about this at the beginning of class. You would find the most complete legal description in the deed. Number 9, exceptions and reservations. If you have an exception or a reservation placed in a deed, is it going to be for the benefit of the grantor or the grantee? It's going to be for the benefit of the grantor. And the reason is I'm saying to you, I'm giving you this property except for the back right corner. I'm going to give you this property but reserve myself the right to cross over your property, get up to the beach, rather than having to walk around the block. That's for my benefit, not your benefit. So, again, if they ask you exceptions and reservations, who do they benefit? They would obviously benefit the grantor, because I'm giving you the property except for a certain portion, or I'm reserving myself something to do with that property. So, again, exceptions and reservations, they benefit the grantor. Let's see, now on the bottom right here of 299, number 12, delivery and acceptance. For a deed to hold validity, there must be delivery and acceptance, which means I deliver it to you and you accept it. And that's voluntary delivery and acceptance. That's not like me just holding my deed and showing it to you, snatching it and running away with it. That's not delivery and acceptance. Delivery is me delivering it with intent and you accepting it with intent. It's, you know, it's a two-party thing there, because to give you guys another example, let's say I hate John Smith. And I say in my will, when I die, give this contaminated, you know, crappy property to John Smith. So when I die and that property is left to John Smith in that circumstance, you know, he's not going to want that property. So he's not obligated to accept it, even though I tried to give it to him. So there must be voluntary delivery and acceptance there. So again, in order for a deed to be valid, there must be voluntary delivery, which means I, as the grantor, voluntarily deliver it to you, and you voluntarily accept it. So again, you must have voluntary delivery and acceptance. And then if you turn the page here, go to page 300, we start getting into recording, acknowledgement, things like that. So when you buy a house, it's not like required by law that you record your deed. With that being said, it's pretty much automatically getting recorded by your attorney or title company. So it's part of your closing costs and whatnot. But you know, with that all said, the reason why they do record your deed, they want it put on the public record that you actually do own that property. They want to make sure the public knows that. We call that constructive notice. So that, God forbid, there's a fraudulent second sale. It's already on the public record that you own that property. So if that fraudulent second buyer says, I didn't know he owned that property, it's assumed by law they knew that you own that property because it was placed onto the public records there. And we call that constructive notice. So I'm going to put a few things up here. Probably have 5 different things about recording. So we're going to talk about this here now. So we're going to talk about recording now. So first and foremost, the first thing to probably write down is that recording is not required. So again, recording is not required. You don't have to record documents, so it's not required. So they say, which of the following is not required when purchasing a home and obtaining a deed? You're not required to record. So again, recording is not required. And if it's not required, why do people do it? The reason why people do this, it provides what's called constructive notice. When I record a document, I enter it onto the public record. Every single member of the public is assumed by fact to know about that. So a home that I own today, my deeds are recorded. Everybody who's watching this video is assumed to know that I own that home. Why? Because constructive notice. It was added onto the public record, and you know, again, we recorded it. Therefore, everybody's required by law to know about that, or assumed by law to know about that. So, number 2, what does recording do? It provides what we call constructive notice. What constructive notice means, again, once a document is added onto the public record, every member of the public is assumed to know about that as a fact. So again, recording provides what we call constructive notice. That states when a document is added onto the public record, all members of the public assumed to know as fact. So again, constructive notice, what this states here, when a document is added onto the public record, then all members of the public, they are assumed to know about this as a fact. So that's constructive notice. What recording also does, in particular for lien holders, it sets priority of lien holders. Lien holders are paid out based on the order of recording. So if I have a contractor and an electrician both do work on my house, I don't pay either of them. Let's say the contractor did work in February, the electrician did work in March, hypothetically. If I didn't pay either of them, if the electrician were to place their lien first and the house were to be foreclosed on, they get paid first, even though they did the work after the contractor. Because why? Lien holders are paid out based on the order of recording. So number 3 here, what recording does, it sets priority of lien holders. So number 3, lien holders are paid in order of recording. So again, lien holders, they are paid out based on the order of recording, except for one lien, a property tax lien. A property tax lien would take precedence over all liens. You could have, 1,000 liens on your home. The second you don't pay your property tax, that jumps everybody. So I'll note that up here too. So again, except for a property tax liens are first priority. They would take precedence over all liens. And a property tax lien takes precedence over all liens. Again, a property tax lien would take precedence over all liens. And if they were to ask you where would you go to record, you go to the county seat. So the county seat is where you would record. So like in Bergen County, we'd go to Hackensack, in Passaic County, Patterson, Essex, Newark, so on and so forth. So if they were to ask you where does recording get accomplished, that gets done at the county seat. And last but not least, they may ask you, what must be done prior to recording? You must acknowledge the document prior to recording, which is basically the same thing as notarization. On the test, I just commonly find to use the words acknowledgement. So if they ask you what must be done prior to recording, you must acknowledge prior to recording. And when you go to get something acknowledged, it's taken by a notary public, which is somebody who notarizes things, right? So again, if they ask you like who takes an acknowledgement, a notary public. Who gives it? The party signing the instrument, right? So if they were to ask you just first and foremost, what must be done prior to recording, you must acknowledge prior to recording. So number 6 here, you must acknowledge prior to recording. So again, you must acknowledge prior to recording. So if they're asking any questions on that, again, you must acknowledge prior to recording. That's a little bit on recording here. Now, one of the other things, the last thing we'll go over in this chapter here, on the bottom left of 300, it talks about the realty transfer fee. Now, the realty transfer fee, the easiest way to figure this out, you go online and you type in New Jersey realty transfer fee calculator. Really simple as that. But basically, what it is, every time that you sell a house in New Jersey, you as a seller have to pay a realty transfer fee to the state. If you are a senior, age 62 or older, there is a discount on that. You can't really go through all the math right now and how you equate these things, but I'm just making mention of this because if on the test they ask you like the realty transfer fee, how is that indicated on the closing statement? It's what we call a debit to the seller. A debit means an expense the seller incurs. So again, this realty transfer fee, if you want to write down one thing for it, on the closing statement, it is a debit to the seller, which simply means an expense to the seller. So again, every time a seller sells a house, they're going to have to pay a realty transfer fee to the state. That's what we call a debit to the seller. All right, so this was a quick, condensed, basically 30-minute version of Chapter 12, which is deeds. So if you guys have any questions, feel free to email me on this. And again, if you guys have any, if you're not a student in our school yet, feel free to call our school if you'd like to join our school. Our phone number is 201-843-7277. Thank you, guys.